I was standing on my back porch when I first noticed the construction equipment rolling onto my property, and by the time I ran down there to stop them, they had already broken ground on what would become the biggest headache of my life. My name is Quentin Dawson, and I own 43 acres in Riverside County, California, about 15 miles outside of Temecula. I bought the property 6 years ago when real estate was still somewhat reasonable, and I built my dream home right at the front of the lot. The back 35 acres were mostly untouched land, rolling hills with some oak trees and native brush. I liked having that buffer between me and the rest of the world. Privacy was what I paid for, and privacy was what I expected to keep. That morning in late April started like any other. I was drinking my coffee and checking emails when I heard the rumble of heavy machinery. At first, I thought it was coming from the highway, but the sound got louder and closer. I stepped outside and saw the dust cloud rising from my back acreage. My stomach dropped. I jumped in my truck and drove the dirt road that wound through my property. When I reached the back section, I counted at least 6 excavators, 2 bulldozers, and a small army of workers in hard hats and orange vests. They were clearing the land, leveling the ground and marking out what looked like a massive construction project. I slammed on my brakes and jumped out. "Hey, what the hell is going on here? This is private property." A foreman in a white hard hat turned to look at me. He was a thick-necked guy with a clipboard and an expression that said he dealt with angry people every day. "You got a problem, buddy?" "Yeah, I got a problem. This is my land." "Who authorized this?" He flipped through his paperwork. "Says here this project was approved by the Sunset Ridge HOA board. All the permits are in order." "I'm not in an HOA," I said, my voice rising. "I specifically bought property that wasn't in one. There's been a mistake." The foreman shrugged. "Look, man, I just do what the paperwork tells me." "You got an issue. Take it up with them." He handed me a business card with the HOA's contact information. I stood there fuming as the machines continued their work. This had to be some kind of administrative error. My property deed was crystal clear. I owned all 43 acres free and clear, with no homeowner association attachments. I had made absolutely certain of that before I signed anything. Back at the house, I immediately called the number on the card. A cheerful receptionist answered. "Sunset Ridge HOA, how may I help you?" "I need to speak to whoever is in charge. You have construction crews on my property right now, and I didn't authorize any of this." "Oh, are you calling about the storage facility project? Let me transfer you to our board president, Patricia Whitmore." The hold music was some sort of instrumental elevator version of a pop song I vaguely recognized. After 3 minutes, a woman's voice came on the line. She had that particular tone that I had learned to recognize over the years, the one that combined false sweetness with absolute certainty that she was right about everything. "This is Patricia Whitmore. I understand there's some confusion about our community improvement project." "There's no confusion on my end," I said. "Your people are tearing up my land without permission. I need them off my property immediately." "Mr. Dawson, is it? I have your file right here. According to our records, the back 35 acres of your property fall within the HOA jurisdiction. The storage facility project was approved by a majority vote of the board last month. All property owners received notification by mail. I never received anything because I'm not part of your HOA. I own this land outright." Patricia made a tusking sound. "I'm looking at the amended boundary map from 2019. Your property is clearly included within our jurisdiction. The previous owner, Mr. Gerald Henderson, signed the agreement when the HOA expanded its territory." My mind raced. Gerald Henderson was the guy I bought the property from. He was an older man who was downsizing and moving to Arizona. Our transaction had been straightforward, handled by a reputable title company. That's impossible. The title search showed no HOA encumbrances. Well, Mr. Dawson, I'm afraid you're mistaken. The amendment was properly filed with the county. I can have our attorney send you the documentation if you'd like, but that will take time, and meanwhile, we're on a tight construction schedule. The storage facility is desperately needed by our community members. I don't care what your community needs. Stop the construction now, or I'm calling the police and my lawyer. That's certainly your right, Patricia said, her voice dripping with condescension. But I should warn you that interfering with an approved HOA project could result in significant fines. I'd hate to see this escalate unnecessarily. Why don't we schedule a meeting? I'm sure we can work this out like reasonable adults. I agreed to meet with her the next day, but only because I wanted to get everything documented. As soon as I hung up, I called my real estate attorney, David Chen. He had handled my property purchase and knew the details intimately. "Quentin, that's absurd," David said after I explained the situation. "I personally reviewed that title. There was absolutely no HOA involvement. Let me pull the files and make some calls. In the meantime, do not sign anything they give you and document everything with photos and videos." I spent the rest of the day doing exactly that. I drove back to the construction site and recorded everything from multiple angles. The workers had made significant progress. They had cleared about 5 acres and were beginning to pour foundation pads. I counted the markers and realized they were planning something enormous. One of the younger workers, a kid who couldn't have been more than 22, noticed me filming. He walked over during his break, wiping sweat from his forehead. "You the owner?" he asked. "Yeah. Did they tell you anything about this project?" "Just that we're building 180 storage units. Big job. Supposed to take about 4 months to complete, 180 units. On my land, without my permission." "Did they mention who owns the property?" I pressed. The kid shrugged. "The HOA lady comes by every morning, real particular about everything. She's got these plans and measurements, and if something's off by even a little bit, she loses it." That night, I barely slept. I kept thinking about what this meant. If they actually completed this project, they would have essentially stolen 35 acres of my property. The value of storage units in this area was substantial. A quick internet search showed that similar facilities charged between $150 to $300 per month, depending on unit size. Even at the low end, we were talking about $27,000 monthly, over $300,000 annually. The meeting with Patricia Whitmore was scheduled for 10 in the morning at the HOA office, which was located in a strip mall about 3 miles from my property. I arrived 15 minutes early with a folder containing all my property documents, including the original deed, title insurance policy, and every piece of paperwork from the purchase. The HOA office was exactly what I expected. Bland beige walls, motivational posters about community values, and a reception desk where a woman in her 60s typed furiously on a computer keyboard. She barely looked up when I entered. "Quentin Dawson. I have a meeting with Patricia Whitmore. She's running a few minutes behind. Have a seat." I sat in one of the uncomfortable plastic chairs and waited. 20 minutes later, Patricia emerged from a back office. She was a woman in her early 50s with short blonde hair styled into a bob that screamed, "I demand to speak to the manager." She wore a pantsuit that looked expensive and carried herself with the confidence of someone who had never been told no in her life. "Mr. Dawson, thank you for your patience. Please, come in." Her office was small but meticulously organized. Every paper was in its place, every pen aligned perfectly. She sat behind her desk and folded her hands, looking at me with what I assumed she thought was a professional smile. "I've reviewed your concerns," she began before I could say anything, "and I understand why you're confused. Property law can be quite complex." "I'm not confused," I said firmly. "I own that land. You're trespassing and conducting unauthorized construction." Patricia opened a folder and slid a document across the desk. "This is the 2019 HOA Boundary Amendment. As you can see, it clearly includes your property." I looked at the document. It was official looking, with all sorts of legal language and a map showing the expanded HOA territory. My property was shaded in with the rest of the HOA parcels. "When was this filed?" I asked. "March 2019. Properly recorded with the county recorder's office." "I bought my property in January 2020. The title company found no HOA involvement." Patricia's expression shifted slightly, a crack in her perfect facade. "Title companies make errors. It happens more often than you'd think." "Not this one. They're one of the best in the state." I pulled out my own documents. "Here's my deed. Here's the title insurance policy. Here's the property survey. None of them mention an HOA." She barely glanced at my papers. "Mr. Dawson, regardless of what you believe, the HOA has legitimate authority over that portion of your property. The storage facility is being built to serve our community members who need additional space. It's a valuable amenity. Built on my land without my permission. Built on HOA-controlled land with full board approval." I leaned forward. "Let me make this simple. Stop the construction immediately, restore my land to its original condition, and we can avoid legal action. Continue, and I'll sue the HOA, you personally, and everyone involved." Patricia's smile turned icy. "That would be unfortunate. Legal battles are expensive and time-consuming. And if we're right about the jurisdiction, which we are, you'll be responsible for our legal fees as well as your own. Plus the fines for interfering with HOA business. Those can add up quickly. We're talking tens of thousands of dollars. I'll take my chances." "There's another option," she said, leaning back in her chair. "We could negotiate an easement agreement. The HOA would compensate you for the use of the land. Something nominal, of course, since we technically already have the rights, but as a gesture of goodwill." "How nominal?" $500 per month. I actually laughed. "You're going to make over $25,000 monthly from those storage units, and you want to pay me $500. "We have significant overhead costs," Patricia said defensively. "Management, maintenance, insurance, liability. The HOA isn't a profit-generating entity, Mr. Dawson. Any revenue goes back into community improvements." "Improvements on my land?" "The answer is no." I stood to leave. Patricia remained seated, her expression hardening. "You're making a mistake. The HOA has substantial resources and excellent legal representation. We don't lose these disputes." "First time for everything," I said and walked out. David Chen called me that afternoon with news that made my blood pressure spike. "Quentin, I found the 2019 amendment. It was filed with the county, but here's the thing. It was filed improperly. The notice requirements weren't met, and more importantly, your previous owner, Gerald Henderson, never actually signed the agreement." "What do you mean?" "The HOA claims he agreed to include his property in the expanded boundaries, but there's no signature on file. Without the property owner's consent, the amendment is invalid as it applies to your land. So they're completely in the wrong." "Yes, but there's a complication. Because the amendment was recorded, it created a cloud on your title. We need to file a quiet title action to clear it up. That's a lawsuit that establishes your ownership rights definitively." "How long will that take?" "Months, maybe longer if they fight it. and in the meantime they could potentially continue construction. Can't we get an injunction? We can try. I'll file for a temporary restraining order first thing tomorrow morning. We need to stop the construction while this gets sorted out. The next day, David filed the emergency motion. The hearing was set for the following week, which felt like an eternity while bulldozers continued reshaping my land. I drove out there every day to document the progress and make sure they weren't expanding beyond what they had already started. On the third day, I encountered Patricia at the construction site. She was wearing designer sunglasses and pointing at various things while speaking to the foreman. When she saw me, she didn't look surprised. "Mr. Dawson, checking on our progress." "Your progress on my land that you're illegally developing. We've been over this. The land is under HOA jurisdiction. Then you won't mind that I've filed a lawsuit and requested an emergency injunction to stop the construction." That got her attention. Her mouth tightened into a thin line. "You're wasting everyone's time and money." "Funny, I was thinking the same thing about you." The HOA board voted unanimously to move forward with this project. We represent over 400 homeowners who will benefit from these storage units. Are you really going to stand in the way of an entire community's needs because of your stubborn refusal to accept reality? The reality is that you're trespassing. The reality is that your 2019 amendment was filed without the property owner's consent. The reality is that you're about to be hit with a lawsuit that's going to cost your precious HOA a fortune. Patricia stepped closer, lowering her voice so the workers couldn't hear. "You seem like an intelligent man, Quentin. Let me explain how this works. The HOA has attorneys on retainer. This costs us nothing to fight, but you'll be paying your lawyer by the hour. Every motion, every hearing, every piece of paperwork. David Chen charges at least $400 an hour, doesn't he? How much is your pride worth? More than $500 a month, I'll tell you that. What if we increased our offer? Say $2,000 per month." I almost laughed again. "Patricia, those storage units will generate over $300,000 annually. You built them on my land without permission. If anyone's paying rent here, it's going to be you to me." "Not $2,000 a month, market rate." Her face flushed red. "That's absurd. The HOA can't afford that kind of payment. Then you shouldn't have built on property you don't own." "We do own it. We have the legal authority." "No signature, Patricia." "Gerald Henderson never agreed to include his property in your expansion. Which means when I bought it from him, I bought it free and clear. You can fight that in court all you want, but you're going to lose." She pulled off her sunglasses, and I could see the rage in her eyes. "You have no idea what you're dealing with. The Sunset Ridge HOA has been in operation for 30 years. We have connections throughout the county government, the planning commission, everywhere that matters. You're one person trying to fight an established institution. Then it should be an interesting fight." I walked away, leaving her standing there fuming. As I drove back toward my house, I felt a mix of anger and satisfaction. This woman had overstepped so dramatically that I almost couldn't believe it. The sheer arrogance required to build nearly 200 storage units on someone else's property was staggering. The court hearing for the temporary restraining order was scheduled for the following Tuesday. David prepared a comprehensive brief laying out the facts. My ownership of the property, the lack of consent from the previous owner, and the ongoing irreparable harm being caused by the construction. He attached photos showing the extent of the development, and included declarations from the title company confirming that no HOA involvement had been found during the original title search. The day before the hearing, I received a certified letter from the HOA's attorney, a woman named Susan Kaplan from a firm in San Diego. The letter was 5 pages of legal threats and demands. It claimed I was interfering with lawful HOA business, cited various sections of California law regarding homeowner associations, and threatened to seek damages against me personally if I continued my harassment of the construction crews. I forwarded it to David, who called me within an hour. "They're trying to intimidate you. This is standard aggressive posturing. Ignore it. They're really committed to this lie. They've invested too much to back down now. If they admit they made a mistake, they're liable for all the costs of reversing the construction, plus your damages. They're hoping you'll give up or settle for pennies on the dollar. Not happening. Good. See you in court tomorrow." The courthouse in Riverside was a modern building with high security. I met David in the lobby at 8:30 in the morning. He was carrying 2 briefcases full of documents and looked ready for battle. "How do you think it'll go?" I asked as we went through the metal detectors. "The law is on our side. The question is whether the judge will issue an immediate TRO or want more evidence. Some judges are reluctant to stop construction projects without being absolutely certain. The evidence seems pretty clear to me." "It is, but you'd be surprised what judges do sometimes." We rode the elevator to the 4th floor and found the right courtroom. It was smaller than I expected, with about 30 seats for spectators and a raised bench where the judge would sit. Patricia Whitmore was already there with Susan Kaplan and another attorney, a tall man with silver hair who looked like he spent his weekends on a yacht. Patricia saw me and whispered something to her attorneys. Susan Kaplan turned and gave me a cold stare. I smiled and waved. David elbowed me. "Don't antagonize them." "Sorry, couldn't resist." The bailiff called the court to order and Judge Michael Rodriguez entered. He was a middle-aged Hispanic man with a serious expression. Everyone stood until he sat down. "Good morning. We're here on the matter of Dawson versus Sunset Ridge Homeowners Association. I've reviewed the briefs from both parties." "Mr. Chen, you're seeking a temporary restraining order to halt construction on your client's property. Is that correct?" David stood. "Yes, Your Honor. The defendant HOA is conducting unauthorized construction on land owned exclusively by my client, Quentin Dawson." Judge Rodriguez looked at the HOA attorneys. "Miss Kaplan, your response." Susan Kaplan stood smoothly. "Your Honor, the Sunset Ridge HOA has proper jurisdiction over the property in question. A boundary amendment was filed and recorded with the county in 2019, 2 years before Mr. Dawson purchased the property. He bought with constructive notice of the HOA's authority. This is a case of buyer's remorse, not unlawful construction." "Your Honor," David interjected, "may I respond?" "Go ahead." The 2019 amendment Miss Kaplan references was never signed by the property owner at that time, Gerald Henderson. Without his consent, the amendment is invalid. California law is clear that an HOA cannot unilaterally expand its jurisdiction to include property without the owner's agreement. The recording of an unsigned document doesn't make it valid. Judge Rodriguez frowned. "Miss Kaplan, do you have Mr. Henderson's signature on the amendment?" Susan Kaplan glanced at her co-counsel, then back at the judge. "Your Honor, the amendment was approved by the HOA board and properly recorded. The signature requirement is a technical issue that doesn't affect the validity of the board's action." "That's not a technical issue, Miss Kaplan. That's a fundamental requirement of property law. You can't just decide someone's property is now under your control without their consent. The property was vacant land at the time, Your Honor. Mr. Henderson had abandoned any meaningful use of it. The HOA was acting in the community's best interest. The best interest argument doesn't override property rights." Judge Rodriguez looked at the paperwork in front of him. I'm going to issue a temporary restraining order halting all construction on the property, pending a full hearing on the merits. The defendants are ordered to cease all work immediately and to not enter the property without Mr. Dawson's express permission. We'll schedule a preliminary injunction hearing for 3 weeks from today. Patricia Whitmore made a sound that was half gasp, half indignant squeak. Susan Kaplan maintained her composure, but I could see her jaw tighten. "Your Honor," she said, "the HOA has already invested over $200,000 in this project. Stopping now will cause significant financial harm." "Then you should have made sure you had the legal right to build before breaking ground," Judge Rodriguez said dryly. "The restraining order is granted. Anything else?" "No, Your Honor," David said, barely suppressing a smile. "We respectfully disagree with the court's ruling," Susan Kaplan said. "Your disagreement is noted. This hearing is adjourned." As we left the courtroom, I felt a wave of relief. The construction would stop, at least temporarily. Patricia and her attorneys clustered in the hallway, speaking in urgent whispers. As I passed them, Patricia glared at me with pure hatred. Outside the courthouse, David shook my hand. "Good first step, but this is far from over. They're going to fight hard at the next hearing." "I know, but at least the bulldozers will be quiet for a while." That afternoon, I drove to the construction site. A notice had been posted on the fence surrounding the area. "Work suspended by court order." The machinery sat silent, and the workers were gone. It felt like a small victory, but I knew Patricia Whitmore wasn't the type to accept defeat. Over the next 3 weeks, my life became consumed with the legal battle. David filed a comprehensive quiet title action, naming the HOA, Patricia Whitmore individually, and the construction company. We sought not just a declaration of my ownership rights, but also damages for the harm caused to my property. The HOA fought back aggressively. They filed motions to dismiss, arguing that I lacked standing, that the case should be heard in arbitration according to HOA bylaws I had never agreed to, and that the court lacked jurisdiction for various technical reasons. David batted down each motion with detailed responses, citing case law and procedural rules. Discovery began, which meant both sides could request documents and information from each other. David subpoenaed all records related to the 2019 boundary amendment. What came back was enlightening and infuriating. "Look at this," David said during one of our meetings at his office. He spread out a series of emails printed from the HOA's files. "These are internal communications between Patricia Whitmore and the other board members." They knew Henderson hadn't signed the agreement. I read through the emails. One from Patricia to another board member, a man named Robert Jennings, said, "Gerald Henderson is refusing to participate in the expansion. He says he plans to sell and doesn't want any HOA involvement. We should proceed with filing the amendment anyway. By the time anyone notices, it'll be established fact." "That's fraud," I said. "It's certainly evidence of intentional wrongdoing. And look at this one, dated just after you purchased the property." David pointed to another email. "Patricia tells the board that the new owner seems unaware of the HOA's claim and suggests they wait a few years before exercising their rights to avoid suspicion. She planned this from the beginning. It looks that way. This strengthens our case significantly. It shows they knew they didn't have legitimate authority but proceeded anyway." The preliminary injunction hearing arrived. This time, the courtroom was more crowded. Several HOA board members showed up to support Patricia, along with a handful of homeowners who apparently wanted the storage units badly enough to skip work on a Thursday morning. Judge Rodriguez took the bench and got straight to business. "We're here to determine whether the temporary restraining order should be converted to a preliminary injunction pending trial." Miss Kaplan, I assume you have arguments on behalf of your clients. Susan Kaplan stood with a thick binder. Your Honor, we've prepared extensive evidence showing that the HOA acted properly and that Mr. Dawson's claims are without merit. For the next hour, she presented testimony from Patricia Whitmore, Robert Jennings, and the HOA's property management company. They all insisted that the 2019 amendment was valid, that proper procedures had been followed, and that Mr. Henderson's signature wasn't required because he had verbally agreed to the expansion. When it was David's turn, he methodically destroyed their arguments. He presented the emails showing they knew Henderson hadn't agreed. He called a witness from the title company who testified that their search had found no HOA involvement. And he called Gerald Henderson himself, who appeared by video conference from Arizona. Gerald was 83 years old and spoke slowly but clearly. I never agreed to any HOA expansion. That woman Patricia called me several times trying to get me to sign something, but I refused. I told her I was selling the property and wanted nothing to do with any homeowner association. That's why I was happy when Quentin bought it. I knew he wanted to keep it private, just like I had. Did you ever give verbal agreement? David asked. Absolutely not. I told her no every time she asked. Susan Kaplan tried to shake his testimony on cross-examination, suggesting his memory might be faulty given his age, but Gerald was sharp. Young lady, I might be old, but I remember this very clearly. That woman harassed me for months. I started screening her calls. After all the testimony, Judge Rodriguez didn't need long to decide. Based on the evidence presented, it's clear that the HOA did not have the property owner's consent to include this parcel in their expansion. The 2019 amendment is invalid as applied to Mr. Dawson's property. The preliminary injunction is granted. The defendants are prohibited from entering or conducting any work on the property. Furthermore, given the evidence of intentional wrongdoing, I'm ordering the defendants to restore the property to its original condition at their expense within 90 days. Patricia Whitmore stood up. Your Honor, that's impossible. We can't just tear down everything we've built. You shouldn't have built it in the first place, Miss Whitmore. Sit down. The silver-haired attorney, who I learned was named Richard Foster, whispered urgently to Patricia, who reluctantly sat down, her face crimson with rage. One more thing, Judge Rodriguez continued. I'm referring this matter to the district attorney's office for investigation of potential fraud and forgery. Filing false documents with the county is a serious matter. That got everyone's attention. Patricia went pale. Susan Kaplan quickly stood. Your Honor, that's not necessary. This was a civil dispute over property boundaries, not a criminal matter. That's for the DA to decide. This hearing is adjourned. In the hallway outside the courtroom, Patricia confronted me directly. Her carefully maintained composure had completely shattered. You've ruined everything. Do you have any idea how much that storage facility meant to this community? I don't care. You tried to steal my land. We weren't stealing anything. We had every right. You had no rights. You forged documents and trespassed, and now you're going to pay for it. The HOA will be bankrupt. Our reserves aren't enough to cover the demolition costs plus our legal fees. 400 homeowners are going to see their dues skyrocket because of your selfishness. Maybe you should have thought about that before you broke the law, Patricia. Her husband, a quiet man who had been sitting in the back of the courtroom, came over and took her arm. Patricia, let's go. This isn't over, she hissed at me. Yeah, it is. David and I went to lunch to celebrate. That went better than I expected, he said over sandwiches. The judge really hammered them. What happens now? They have 90 days to demolish what they built and restore your land. If they don't, We can get a court order allowing us to hire contractors to do it and bill them for the costs. Plus, you can file for damages. The harm to your property, your legal fees, your time and stress. We're talking significant money. I just want my land back the way it was. You'll get that, but you deserve compensation too. They caused real harm. Over the next week, the HOA tried to negotiate. Susan Kaplan called David multiple times, proposing various settlement offers. They offered to pay me $25,000 to allow them to keep the storage units. Then $50,000. Then $100,000 plus 10% of the revenue. I rejected every offer. They need to tear it down and restore my property. That's what the judge ordered. But demolition didn't begin. The 90-day deadline approached and nothing happened. David filed a motion for contempt. The hearing was swift and brutal. Your Honor, Susan Kaplan explained, the HOA is experiencing financial difficulties. The demolition costs are estimated at over $300,000. The association doesn't have those funds available. That's not my client's problem, David responded. They were ordered to restore the property. Their financial situation doesn't excuse defying a court order. Judge Rodriguez was not sympathetic. The defendants have 30 days to begin demolition and 60 days to complete it. If they fail to comply, Mr. Dawson is authorized to hire contractors to do the work, and the defendants will be liable for all costs plus 25% penalty. Additionally, the HOA board members are personally liable if the association cannot pay. That changed everything. Patricia and the other board members suddenly faced personal financial ruin if they couldn't figure out how to fund the demolition. Emergency HOA meetings were held. According to the notice I received, since my property had briefly been claimed as part of the HOA territory, I was technically entitled to attend. I decided to go to the next meeting, which was held at a community center in the Sunset Ridge development. About 50 homeowners showed up and the mood was angry. When I walked in, conversations stopped. People stared. Patricia stood at the front with the other board members. When she saw me, her expression hardened. Mr. Dawson, I'm surprised you have the audacity to show your face here. I'm entitled to attend. You claimed my property was in the HOA, remember? You're not welcome. Too bad. This is a public meeting of the HOA board. Sit down and get started. A woman in the audience stood up. Who is this guy? This is Quentin Dawson, Patricia said bitterly. He's the reason your HOA dues are about to triple. That caused an uproar. People started shouting questions. Patricia banged a gavel. Everyone calm down. Let me explain the situation. She gave her version of events, which painted me as an unreasonable neighbor who was destroying the community over a technicality. We had a wonderful plan to provide storage units for all of you, units you desperately need. But Mr. Dawson filed a lawsuit based on a missing signature on a document from years ago. Now the court is forcing us to tear down the entire facility at massive expense. That's not quite accurate, I said loudly. You're out of order, Patricia snapped. No, you're out of excuses. You built on my property without permission. You forged documents. You lied to the court. And now you're lying to these people. An older man in the front row turned to look at me. Is it true they built on your land without asking? Completely true. I woke up one morning to find bulldozers on my property. The HOA claimed they had authority based on an amendment that was never properly executed. But we need those storage units, a woman said. My garage is full. I don't have anywhere to put my things. Then the HOA should have built them on land they actually owned or had legitimate rights to. Patricia tried to regain control. The point is, we now face a financial crisis. The demolition will cost over $300,000. Our reserves are only $90,000. We need to levy a special assessment of $5,000 per household to cover the costs. The room erupted. $5,000 was a lot of money for most families. People started shouting at Patricia, at each other, at me. One man stood up and yelled, "Why can't we just work something out with this guy? Pay him rent or something." "We tried," Patricia said. "He refused every reasonable offer." "Your offers weren't reasonable," I corrected. "You offered me a fraction of what the storage units would generate in revenue. Why would I agree to that?" "Because it's the right thing to do for the community," Patricia shot back. "The right thing was not building on my land in the first place." A younger woman raised her hand. "Can someone explain this from the beginning? I'm confused about whose land it actually is." I stood up fully. "I own 43 acres. The HOA built storage units on 35 of those acres without my permission, without my knowledge, and based on a fraudulent document. The court has ruled in my favor 3 times now. This isn't complicated. They trespassed and now they have to fix it." "But why won't you let them keep the units and just pay you?" another person asked. "Because they're on my property. I didn't want them there. I bought land specifically to avoid having structures and people and noise on it. The HOA violated my property rights. Would you want someone to build something on your land without asking?" That seemed to resonate with people. The tone in the room started to shift. Instead of being angry at me, homeowners started directing their frustration at Patricia and the board. "How did this happen?" one man demanded. "How did you spend hundreds of thousands of dollars on a project without making sure you had the right to build it?" "We did our due diligence," Patricia insisted. "The amendment was on file with the county." "An amendment that wasn't signed," I added. "They knew it wasn't signed. There are emails proving they knew." "That's privileged information," Susan Kaplan said quickly. She was sitting in the corner, apparently there to provide legal advice. "It was submitted as evidence in court. It's public record now." The meeting devolved into chaos. Homeowners argued with each other and with the board. Some people thought they should try harder to negotiate with me. Others thought the board should resign for getting the HOA into this mess. A few people even suggested they should refuse to pay the special assessment and let the board members face personal liability. Patricia tried to restore order but failed. Eventually, she adjourned the meeting early, which made people even angrier. As everyone filed out, several homeowners approached me. "Is there really no way to work this out?" a woman in her 40s asked. $5,000 is going to hurt a lot of families here." "I'm sorry about that," I said honestly. "But this isn't my fault. The HOA leadership made terrible decisions. They gambled with your money and lost. What if we offered you a fair price, real market value for the rental?" "What's fair market value?" She pulled out her phone and did some quick math. "If those units would generate $300,000 a year in revenue, and you own the land, you should get at least half, maybe $150,000 annually." I considered it. That was about $12,000 a month, which was substantial, but there was a principle at stake. "The problem is, I never wanted this. I don't want to be a landlord to an HOA. I don't want the liability, the headaches, the ongoing relationship with people who tried to steal from me." "I understand, but please think about it. A lot of innocent people are going to suffer because of what Patricia did." I told her I would consider it, but I wasn't optimistic. The trust was broken. Even if we worked out a rental agreement, I would always be waiting for the HOA to try something else. The 30-day deadline came and went. No demolition began. David filed another contempt motion, and this time Judge Rodriguez was furious. He ordered Patricia Whitmore and the entire HOA board to appear personally. "You were given clear instructions," the judge said from the bench. "You've now violated 2 court orders. I could jail you for contempt." Patricia's new attorney, a third lawyer since Susan Kaplan had apparently quit the case, spoke up. "Your Honor, the HOA is actively seeking financing to fund the demolition. These things take time. You've had 4 months. How much more time do you need? We're exploring a loan from a bank that specializes in HOA financing. The application is pending. You have 2 more weeks. If demolition doesn't begin by then, I'm issuing bench warrants for the arrest of all board members for contempt of court. And Mr. Dawson is authorized to proceed with hiring his own contractors. The defendants will be liable for all costs, and I'm imposing a 50% penalty instead of 25%. Patricia looked like she might cry. The other board members sat in stunned silence. Being threatened with jail time for an HOA dispute was clearly not something they had ever imagined. The threat of arrest worked. Within a week, a demolition company showed up at the construction site and began tearing down the storage units. It was satisfying to watch, I had to admit. The concrete pads were broken up and hauled away. The metal structures were dismantled and trucked off. Slowly, my land reappeared, but the demolition revealed another problem. The construction had destroyed the natural landscape. The oak trees were gone. The native plants were gone. The rolling hills had been flattened. What remained was bare dirt and rocks. David filed another motion seeking additional damages for environmental restoration. We hired an ecological consultant who estimated it would cost another $150,000 to replant native vegetation, restore the natural contours of the land, and replace the oak trees with mature specimens. The HOA balked. They couldn't afford it. Patricia Whitmore resigned from the board in disgrace. 2 other board members resigned as well. The new board president, a reasonable-seeming man named Thomas Rivera, reached out to David to discuss settlement. "My client is willing to negotiate," David told me after the initial conversation. "They're offering a payment plan for the restoration costs plus $50,000 in damages for your trouble." "How long is the payment plan?" 5 years. They'd pay $3,000 a month plus they'd agree to stay off your property forever and remove any claim from the county records. I thought about it. The money was significant, though not nearly enough to compensate for the stress and time I had invested in this fight. But I was also tired. The legal battle had consumed nearly a year of my life. I wanted it to be over. "What about criminal charges?" I asked. The judge referred it to the DA. I checked on that. The DA's office investigated and decided not to file charges. They said it was a civil matter, and while the HOA's conduct was improper, it didn't rise to the level of criminal fraud. That was disappointing but not surprising. White-collar crimes rarely resulted in serious consequences. "Okay, I'll accept the settlement on 3 conditions. First, Patricia Whitmore has to sign a personal guarantee for the payments. If the HOA defaults, she's liable. Second, they have to publish a full apology in the local newspaper explaining what they did wrong. Third, all of this gets recorded as a permanent easement violation on the HOA's property records. So if they ever try to sell the common areas or expand again, this history follows them." David relayed my terms. Thomas Rivera agreed to all of them. Patricia initially refused to sign the personal guarantee, but when David pointed out the alternative was continued litigation and potential personal bankruptcy, she relented. The settlement was finalized in early March, almost a year after the construction equipment first rolled onto my property. The apology ran in the Temecula Valley News. The Sunset Ridge Homeowners Association apologizes to Quentin Dawson for unauthorized construction conducted on his property in 2024. The HOA acted without proper legal authority and has agreed to restore Mr. Dawson's land and provide compensation for damages. The former board leadership made serious errors in judgment that have resulted in significant financial costs to the association. We are implementing new procedures to ensure such mistakes never happen again. It wasn't everything I wanted. I would have preferred a full admission of fraud and a groveling apology from Patricia personally, but it was something. The restoration work began in late March. The company David hired specialized in native California landscapes. They brought in soil, reshaped the hills, and planted hundreds of native shrubs, grasses, and wildflowers. Mature oak trees were transported and planted where the original ones had been destroyed. It wasn't exactly the same as before, but it was close. By May, my back acreage was beginning to look natural again. The plants needed time to establish, but the bones of the landscape were back. I could stand on my porch and look out at rolling hills instead of bare dirt and demolished concrete. The monthly payments from the HOA arrived like clockwork. $3,000 on the first of each month, automatically deposited into my account. It was some consolation for everything they had put me through. I thought that was the end of it. I was wrong. In July, I received a strange letter from a law firm in Los Angeles. It was from a lawyer representing a company called Storage Pro Solutions. The letter explained that Storage Pro had entered into a contract with the Sunset Ridge HOA to lease and operate the storage facility on my property. When the facility was demolished, Storage Pro lost their investment in equipment and pre-construction costs. They were now suing me for tortious interference with a business relationship. I called David immediately. "Are you kidding me with this? Let me see the letter." I scanned and emailed it to him. He called back 10 minutes later. "This is garbage. You can't interfere with a contract that was based on illegal activity. I'll file a motion to dismiss and will probably countersue for abuse of process." How much are they claiming I cost them? $500,000. That's insane. It's a shakedown. They're hoping you'll settle for some amount just to make it go away. Don't worry about it. But I did worry. The idea that I was being sued by a third party for protecting my own property rights was infuriating. David filed the motion to dismiss and included a declaration from me explaining the facts. He also filed a cross-complaint against Storage Pro and the HOA for abuse of process and seeking sanctions. The hearing on the motion to dismiss was in September. The judge, a different one this time, read through the filings with an increasingly incredulous expression. "Let me make sure I understand this," she said to Storage Pro's attorney. "Your client signed a contract with an HOA to operate a storage facility on land the HOA didn't own and had no rights to. The facility was built illegally and then torn down by court order, and now you're suing the actual property owner for interfering." "Yes, Your Honor." Mr. Dawson's litigation caused substantial harm to our client's business interests. Mr. Dawson's litigation protected his property rights. Your client did inadequate due diligence. Motion to dismiss is granted. Furthermore, I'm awarding sanctions of $15,000 to the defendant for having to defend against this frivolous lawsuit. Anything else? Storage Pro's attorney looked deflated. "No, Your Honor." "Then we're done here." That was truly the end of it. Storage Pro paid the $15,000 in sanctions, and I never heard from them again. The HOA continued making their monthly payments. Patricia Whitmore moved out of the Sunset Ridge development, apparently unable to face her neighbors after the scandal. Thomas Rivera turned out to be a competent board president who stabilized the HOA's finances and rebuilt their reputation. I occasionally drove back to check on the restoration work. By the following spring, 2 years after the whole mess started, my back acreage looked beautiful. The native plants had filled in. The oak trees were thriving. You could barely tell there had been any disturbance at all. One afternoon in April, I was standing on my back porch when I saw a car pull up to my gate. A woman got out and pressed the intercom button. I walked down to see what she wanted. "Mr. Dawson?" she asked. "That's me. My name is Jennifer Cortez. I'm a reporter for the Riverside Press Enterprise. I'm doing a story on HOA overreach and abuse of power. Your case came up in my research. Would you be willing to talk to me?" I considered it. Part of me wanted to stay out of the spotlight and just enjoy my peace and quiet. But another part thought that maybe sharing my story could help other people who were dealing with similar situations. "Sure," I said. "Come on in." We sat on my porch and I told her everything. The construction equipment showing up unannounced, the fraudulent documents, the year-long legal battle, the demolition and restoration. She took notes and recorded our conversation with my permission. "This is remarkable," she said when I finished. "Most people wouldn't have fought back this hard. They would have accepted a settlement early on." "It was never about the money," I said. "It was about the principle. I bought this property specifically because it wasn't in an HOA. For them to try to force me into one after the fact, and then build on my land without permission, that was just wrong. I couldn't let them get away with it. What would you say to other people facing HOA problems? Document everything. Know your rights. And don't be afraid to fight if you're in the right. HOAs count on people being too intimidated or too tired to push back. But property rights matter. The law is there to protect you if you're willing to use it." The article ran a few weeks later as a front-page feature. It generated a lot of attention. I received emails and phone calls from people across California and even other states who were dealing with HOA disputes. Some of their stories made my situation look tame. HOAs foreclosing on homes over minor violations. 6-figure fines for painting a door the wrong color. Rules that prohibited the American flag. I couldn't help everyone, but I referred people to David when their situation seemed serious. He ended up developing a subspecialty in HOA litigation and helped several clients successfully fight back against overreaching boards. As for me, I finally got to enjoy my property the way I had always intended. Peace and quiet. Privacy. No one telling me what I could do with my own land. The monthly payments from the HOA continued for the full 5 years as agreed. By the time the final payment arrived, I had received $180,000, which didn't fully compensate for my legal fees and time, but it was something. I used some of the money to install a more robust fence around my property with prominent no trespassing signs. I also set up security cameras covering the back acreage. If anyone tried to build on my land again, I would know within seconds, but no one did. The Sunset Ridge HOA learned their lesson. Thomas Rivera ran the association competently for several years before stepping down. The new leadership seemed to understand the importance of following the law and respecting property rights. Sometimes when I stand on my porch looking at the back acreage, I think about those 80 days when it was covered with construction equipment and storage units. It feels like a weird dream now. Did that really happen? Did an HOA actually try to steal 35 acres of my land? Yes. Yes, they did. And they paid the price for it. The lesson, if there is one, is simple. Know your property rights, stand up for them, and don't let anyone bully you into giving up what's legally yours. HOAs have their place, and many of them operate reasonably. But when they overstep, when they forget that they're not actually above the law, someone has to push back. I'm glad I was willing to be that someone. Not just for my sake, but for everyone else who might face similar situations in the future. The precedent mattered. The message mattered. You can't just take what isn't yours, even if you're an HOA with lawyers and political connections. Property rights won. The little guy won. And my back acreage is exactly what I always wanted it to be: untouched, peaceful, and completely mine. 5 years after this all began, I was contacted by a documentary filmmaker who wanted to include my story in a project about American property rights. I agreed to participate. The documentary featured several cases of government overreach, eminent domain abuse, and HOA problems. My case was presented as an example of what happens when citizens refuse to back down. The documentary premiered at a film festival and eventually aired on a streaming platform. I watched it with a mix of pride and lingering frustration. Pride that I had stood my ground. Frustration that it had been necessary in the first place. After the documentary came out, I heard from Gerald Henderson in Arizona. He called me out of the blue one evening. "Quentin, I just watched that documentary. I had no idea it turned into such a mess. I'm so sorry." "It's not your fault, Gerald. Patricia Whitmore did this, not you. Still, if I had been more careful when she was pestering me, maybe documented her harassment or something, it might have helped your case. We did fine without it. The emails they were dumb enough to put in writing were plenty." He laughed. "She always was arrogant, thought she could do whatever she wanted. I'm glad you took her down a peg." More than a peg. She lost her position, her reputation, and almost ended up in jail. Good. People like that need to learn they can't push everyone around. We talked for a while longer. Gerald told me about his life in Arizona, his grandkids, his retirement hobbies. It was nice to connect with the man who had originally owned this beautiful property and had the good sense to refuse Patricia's schemes. After we hung up, I poured myself a drink and walked out to the back porch. The sun was setting, painting the hills in gold and orange. Native wildflowers swayed in the breeze. Birds called to each other as they settled in for the night. This was what I had bought. This was what I had fought for. And it was worth every moment of the fight. The HOA saga taught me several things about human nature and American society. People in positions of minor authority often let it go to their heads. HOA board members, in particular, seemed prone to developing delusions of grandeur. They started thinking of themselves as important officials rather than volunteers managing a neighborhood pool and enforcing parking rules. Patricia Whitmore was the perfect example. She had probably been a reasonable person at some point. But years of being HOA board president, of having people defer to her at meetings, of wielding her small amount of power over her neighbors, had warped her perspective. She started believing that what was good for the HOA was inherently right, and anyone who disagreed was an enemy of the community. The second lesson was about the importance of documentation and persistence. If I hadn't kept detailed records, taken photos, saved emails, and documented every interaction, the case would have been much harder to win. And if I had given up at any point, accepted one of the lowball settlement offers, or decided the fight wasn't worth it, Patricia would have gotten away with her scheme. The third lesson was about the value of good legal counsel. David Chen was expensive, no question about it. But he was worth every penny. His knowledge of property law, his strategic thinking, his courtroom skills, all of it was essential. People who tried to fight legal battles without proper representation usually lost, even when they were right. And the fourth lesson was that the system, for all its flaws, could still work. Yes, it was slow. Yes, it was expensive. Yes, it was frustrating. But in the end, the courts recognized my property rights and enforced them. The judges saw through the HOA's deceptions and ruled appropriately. Justice was served, even if it took longer than it should have. I became something of a minor celebrity in property rights circles. I was invited to speak at a conference on HOA reform, where I shared my story with an audience of homeowners, attorneys, and legislators. Some states were considering laws to limit HOA power and provide better protections for property owners. I hoped my case would contribute to those efforts. The speaking engagement led to other opportunities. I consulted on a couple of cases involving HOA disputes, providing my perspective as someone who had successfully fought back. I didn't charge for this help. It felt good to use my experience to assist others facing similar battles. One case involved a retired couple in Florida whose HOA tried to foreclose on their home over an unpaid $50 fine. Another involved a veteran in Texas who was prohibited from flying an American flag. Both cases resolved favorably after aggressive legal pushback, and I like to think my advice had helped. Life eventually returned to normal. The monthly payments from the HOA ended after 5 years. The restoration of my back acreage was complete. The legal cases were all closed. The documentary had its moment and faded from public attention. I went back to living quietly on my 43 acres, working remotely for a tech company, enjoying the peace and solitude I had always wanted. But I never forgot what happened, and I never stopped being vigilant. The security cameras stayed up. The fences stayed strong. The no trespassing signs remained visible from every angle. If another HOA or anyone else tried to mess with my property, I would be ready. Sometimes neighbors from the Sunset Ridge development would drive by, probably out of curiosity. I wondered what they thought when they saw my property. Did they resent me for costing their HOA so much money? Did they understand that I was the victim, not the villain? Did they learn anything from what happened? I hoped so. I hoped they looked at their HOA leadership more critically now. I hoped they demanded accountability and transparency. I hoped they would speak up if they saw the board overstepping its authority, because that was the real tragedy of the whole situation. Not what happened to me. I came out fine in the end. The real tragedy was that 400 homeowners had their trust betrayed, and their money wasted by leaders who thought they were above the rules. That kind of betrayal damaged communities and made people cynical about civic participation. One afternoon, about 6 years after everything started, I was working in my garden when a car pulled up. A man in his 30s got out and walked to my gate. He pressed the intercom. "Can I help you?" I asked through the speaker. "Mr. Dawson. My name is Marcus Reynolds. I'm the new president of the Sunset Ridge HOA. I was hoping we could talk for a few minutes." I was curious enough to let him in. We sat on the porch, and he explained why he had come. "I wanted to apologize in person for what the previous board did to you. I've reviewed all the records, and it was inexcusable. Patricia Whitmore abused her position and violated your rights. On behalf of the association, I'm sorry." "I appreciate that. How are things going over there now?" "Better. We've implemented new controls and oversight procedures. No major projects can be approved without a full vote of the membership, not just the board. We hired a new management company, and we've paid off all the debts from the settlement." "That's good to hear." "I also wanted you to know that several of us pushed to have Patricia banned from ever serving on the board again. We added it to the bylaws. Her name is specifically mentioned. She can't hold any HOA position in perpetuity." That made me smile. I like that. "You did our community a favor, even though it didn't feel like it at the time. You exposed serious problems in our governance. We're better off now because you fought back." Marcus stayed for about an hour. We talked about HOA management, property rights, and community governance. He seemed like a genuinely decent guy who actually cared about doing the right thing. When he left, I felt better about the whole situation than I had in years. Maybe something good had come from all the chaos. Maybe the Sunset Ridge HOA really had learned and improved. Maybe future board members would remember what happened and think twice before overstepping their authority. And maybe, just maybe, some other property owner facing a similar situation would hear about my case and find the courage to fight back against injustice. That evening, I stood on my porch and looked out at my back acreage. The oak trees rustled in the breeze. The hills rolled gently toward the horizon. Everything was exactly as it should be: my property, my rights, my victory, and absolutely no HOA storage units anywhere in sight.